I'll now call 125-499 in Ray McVey.
May it please the court, Gail Larkin, Disciplinary Administrator, on behalf of the Office of the Disciplinary Administrator. This is an original action in discipline filed by the Office of the Disciplinary Administrator against the respondent, Jeffrey Lee McVey of Great Bend, an attorney admitted to the practice of law in Kansas in 1993. On March 18th of this year, our office filed a formal complaint against the respondent alleging violations of the Kansas Rules of Professional Conduct and the rules relating to the discipline of attorneys. The respondent timely answered on April 6th. Thereafter, on May 26th, we filed an amended formal complaint, and again, he timely answered on June 14th. In the respondent's answers, he stipulated that he violated KRPC 1.15, which is the safekeeping of property rule. At the hearing on the amended formal complaint, he appeared personally and with counsel, and that hearing was conducted on June 28th, 2022. Following that hearing, the hearing panel concluded that the respondent violated KRPC 1.15, subsections A, B, and D, that the respondent violated KRPC 8.4C, which is the rule that prohibits or that defines professional misconduct involving dishonesty, misrepresentation, deceit, and fraud. And the hearing panel concluded that the respondent violated Rule 210, which is one of our cooperation rules. At the hearing, I argued and the hearing panel agreed that the appropriate discipline in this case is a one-year suspension with the requirement of a 232 hearing following that period of suspension. Because neither party took exceptions to the final hearing report, under Rule 228G, the hearing panel's findings of fact and conclusions of law are deemed admitted. Currently, this case is uncontested, and the only issue before the court today is the appropriate discipline to impose. My recommendation today remains the same as it did at the time of the hearing, and that's a one-year suspension with the requirement of a reinstatement hearing. Give some background facts. In 1993, when the respondent first became a lawyer, he went to work for Brock McPherson in Great Bend. He remained employed with Mr. McPherson until May 29th, 2020. The disciplinary case arises from the respondent's representation of two clients during that practice. The two clients are BG and MK. BG's case, he retained the respondent to represent him in a family law case in March 2020. He paid a $1,000 advance fee in cash, and that fee was to be earned at a rate of $200 per hour. The time it was paid, it was not earned. Rather than see that the unearned fee was deposited into the attorney trust account, the respondent placed the cash into his desk drawer. He had other cash in that desk drawer, and the cash was commingled. The respondent testified that he deposited that account or that cash into an account. He was not sure which account he deposited it to, but he admitted that he used that money for his own personal expenses. Ultimately, the respondent converted the fee paid by BG to his own use to pay those expenses. In that regard, the respondent stipulated that he violated 1.15. I do want to clarify that the respondent provided representation to BG. He didn't complete the representation before his employment with Mr. McPherson ended, but he did provide some representation. And at the hearing, Mr. McVey testified that he believed he had earned the entire $1,000 fee. The fee should have gone to the firm, not to the respondent. In this case, regarding BG, the respondent's conduct violated both KRPC 1.15A and D. Violated subsection A by failing to deposit the unearned fee into the trust account, and violated subsection D when he failed to preserve the identity of the funds by commingling BG's cash with other cash that was the respondent's. In addition, under these facts, the respondent violated KRPC 8.4C because he converted the attorney fee to his own use and used that fee to pay personal expenses. Later, when Mr. McPherson learned that the fee was not properly deposited into the attorney's or into the firm's trust account, he confronted the respondent. The respondent told Mr. McPherson that he forgot to deposit the money. As a result of this, it appears from the complaint that Mr. McPherson filed that he terminated the respondent's employment at that time. Moving on to the second case, and in that case, the client's name is MK, and she's an elderly woman who owned quite a bit of property. And the respondent, and back in about 2010, the respondent began managing her rental properties. She had several rental properties, and as a rental property manager, he would list the properties, locate tenants, collect rent, address minor repairs, and disperse the rental income to MK on a monthly basis. For that, he received 10% of the rent collected. He operated this rental business, or this rental management business, out of the law firm. He used the law firm's letterhead and facilities to do that. Tenants would come in and pay in the office, and he would provide them with a separate receipt book, or receipts from a separate book. In 2012, the respondent drafted a buy-sell agreement on behalf of MK for a contract for deed situation involving property located in Great Bend at 500 Odell. RA and GA were the purchasers of that property through that agreement. After drafting that agreement, the respondent agreed to serve as an escrow agent on that property, and he would receive the payments, he would pay the taxes and the insurance, and then he would remit those the balance to MK on a monthly basis when he provided the rental balance. In 2015, MK sold her properties, and after she sold her properties, the respondent continued to serve as an escrow agent for MK regarding the Odell property. That was the only property that he had involved with after that time. While MK expected to receive those payments on a monthly basis, the respondent often didn't provide those for 5 or 6 months at a time. In 2020, RA came to the office, to the law office, and paid her payment on her home every month. And her standard practice was to pay cash on the last business day of the month. And she paid that way in January, February, March, and April. Respondent did not inform MK that he received those funds, nor did he remit the funds to MK as they were received. After the respondent was terminated from his employment in May of 2020, the respondent sent a letter to RA and GA informing them that he was no longer officing at the McPherson office. He provided them with a new address where they could deliver payments. According to the respondent, he sent a copy of that letter to MK. According to MK, she did not receive it. Now, after the respondent was terminated, MK went to great lengths to try to recover the payments that had been made for January through April. She called his phone, his home phone, and was told that he would be coming to the phone would be set down, and then after a period of time, the phone was hung up. She stopped by his house and saw that cars were there, but nobody answered the door. She called the respondent's mother, as they were acquaintances, and she also stopped by the mother's house. Finally, according to her interview, when she was interviewed by the KBI, she also sent a registered letter to the respondent. Respondent indicated that he never received that letter. It wasn't until August 6, 2020 that the respondent provided MK with the money he was holding on her behalf. He provided her with a cashier's check in the amount of $1,700. Now, the respondent did not have an accounting to establish how much money he owed MK. He paid MK $1,700 because that's what she asked for. Back in 2007, when the respondent first began managing rental properties, he managed them for the law office, for his mom, as well as MK. Over time, he managed them for those 3 entities. He set up an account with Community Bank located in Great Bend, and the idea was the account would be used solely and exclusively for the rental property business. And in fact, in his answer, in his amended answer, that's what he said. It was set up for the sole purpose. But it wasn't a business account, it was a personal account, and it wasn't in a business name, it was in his wife's name and his name. In 2020, that account, and you can see from Exhibit 6 and 7, some of the bank statements that are there, that account rarely had sufficient money to cover the amounts that should have been held solely on MK's behalf. For example, on March 26, 2020, the account should have had at least the January and February payments of that year, totaling $900. The account balance was only $3.90. During the disciplinary hearing, the respondent admitted that he did not use the account for the sole purpose of the rental business. He testified that he used the money that he was holding in escrow to pay his own personal expenses. He stipulated that he violated 1.15 when serving as an escrow agent for his client, MK. In this regard, the respondent violated KRPC 1.15 in 3 ways. First, he failed to deposit the funds in a separate account as required by subsection A. He failed to notify MK that he received funds and he failed to properly deliver those funds, then that's in violation of subsection B. And in violation of subsection D, he failed to preserve the identity of MK's funds. He testified that he placed the cash paid by RA in his desk drawer with other cash, again, commingling his client's funds with his property. In addition to 1.15, the respondent also violated KRPC 8.4C in this regard. He converted MK's property to his own personal use by paying his personal expenses. About a month after Mr. McPherson terminated the respondent's employment, he filed a disciplinary complaint against the respondent. And during the investigation of that complaint, the investigator asked the respondent for certain documents. He asked for complete bank records. He asked for an accounting of the money he held on behalf of MK. And he also asked for a copy of the agreement that established their agreement regarding escrow services. The respondent did not provide those documents as requested by the investigator. Mr. Hazlitt also asked for the accounting and the agreement. Again, he did not provide those in violation of Rule 210.
I have a couple questions about the 210
Certainly.
rule violation. The rule says the attorney must timely respond to a request for information. It strikes me that your allegation and the findings of the panel are that the respondent did not provide documents.
Correct.
Does that fit with Rule 210?
This is how you define respond. To me, when the
And information as well. Sorry to
absolutely.
interrupt.
I think that the rule would have no meaning if we were to just say, if the response were no, I'm not going to provide you those. That's not really responsive to the request. It's not providing what's necessary to kind of complete the disciplinary investigation.
Doesn't your office have subpoena power?
We do.
And so what the way this rule is being interpreted in this case strikes me as essentially making the respondent, it's a shortcut. You don't have to issue subpoenas for documents you want. You can just hold Rule 210 over a respondent and say, if you don't give us all the documents we want, fail to cooperate.
Well, I think that we have to kind of back up one step, and the respondent was required to maintain these documents under Rule 1.15, which talks about maintaining full trust account records. The money should have gone into a trust account. He should have had trust account records for 5 years. So these should have been things that he had in his possession all along. So we weren't asking anything more for him than what he should have been doing in order to comply with Rule 1.15.
What if the response from a respondent to this kind of request is, I will comply with any lawfully issued subpoena? Would that satisfy Rule 210?
So you're saying we should have subpoenaed the records from the respondent rather than from the bank?
Just trying to define the duty under Rule 210. I think that is important if these are going to be rule violations in these cases, that at least as a matter of notice to the bar, what does this duty to respond really entail? Because you're right, it could be read narrowly or broadly. And the narrow reading of it would be that you just simply have to timely respond. And a response could be no, like, I'm not going to give you the documents. That could be a response.
I think that certainly would not be in the spirit of the rule. The spirit of the rule is to provide information so that the disciplinary investigation can proceed orderly. I did a little research on kind of what cooperation is necessary under the rule. And I came across three cases that I think are kind of interesting and kind of helpful in this regard. The first one is kind of the one that we used to always refer to as the cooperation case, and that's Saviano. It's a 1983 case. It's found at 234 Can 268. And it talks about what the, and it's based upon the old Rule 207, which is very similar to the current Rule 210. But it talks about the plain import of this rule is to impose a duty of cooperation regardless of the nature or subject of the complaint. So it's not necessarily the cooperation is not limited to just response. It's talking about aiding in the investigation. The language is simple, the court went on to say that language is simple, straightforward, and unambiguous. It imposes the duty of cooperation on every lawyer under this court's jurisdiction, with one exception, and that's the right against self-incrimination. So, my position is that if we make a request and it doesn't, and furthers the investigation, then it's something that the respondent needs to comply with or be found in violation of Rule 210 as well as 8.1. Another case that I thought was kind of helpful also was I think it's Dudan. It's 292 Can 83. It's a 2011 case. In that case, it talked about rule violations by a retained attorney may be imputed on a lawyer. So that really is going beyond what it was going beyond what I thought the rule meant at the time to be, I mean, really, but it basically is saying, even if the retained lawyer doesn't cooperate, that can be imputed to the lawyer. And finally, in the Corin case, it's a 286 Can 421. In that case, the respondent failed to provide bank records as requested and claimed that computer problems prevented him from complying with the request. In that case, the rule violation was found. Finally, the last little part of Saviano that I want to kind of point out is it talks about, why lawyers are required to cooperate. And it says, the court stated, our procedures ensure that the public, that their grievances, real or imagined, against an attorney will be investigated and resolved promptly and impartially. No procedure can be designed to protect attorneys from groundless complaints. The ability of the disciplinary administrator to investigate, interview, and evaluate without restriction is the best assurance for attorneys that groundless complaints will be terminated as quickly and as efficiently as humanly possible. So I think that those cases kind of taken together really kind of establish why the cooperation rule is important. And I think that clearly was violated in this case.
Do you have to docket a case before you can issue a subpoena?
No, I mean, I think that we have a brand new subpoena rule, and I will look at that and might come back up on my 3 minutes. I'll let you know the answer to that question. Because we specifically talk about initial complaints and reports, and we talk about docketed complaints in the rules. And I'm not sure how that one is phrased, but I will double check that just in a moment. I want to touch briefly, the probation plan is not substantial. It's not detailed. It was not put into place, and it cannot correct the misconduct in this case because the misconduct involved dishonest conduct. Under Stockwell, the court is generally reluctant to grant probation when the misconduct involves fraud or dishonesty because supervision, even the most diligent, cannot often effectively guard against dishonest acts. And then in conclusion, I think that the standard that's appropriate is 4.12, and it provides suspension is generally appropriate when a lawyer knows or should know that he's dealing improperly with client property.
I have one real practical question. You've asked for a reinstatement hearing. In our recent disciplinary opinions that have come out over the last few months, a couple of them followed reinstatement hearings. And if you just look at the dates that are recited, I think, at least in those cases, we were running somewhere around 3 years between the petition for reinstatement and the reinstatement hearing. Can you shed any light on where we might be at now in terms of that delay?
Certainly, I think that in one case in particular, there was a long investigation and there was some delay attributable to the actual petitioner in that case for not getting information back during the course of the investigation. But I think typically once an investigation, once the court determines sufficient time has elapsed to reconsider the prior order of discipline, from that point to through the investigation to the hearing and back before the court, I think it's on average is 9 months. And I think that that question's been asked a lot over the years. And I studied that question, but I haven't had the opportunity to be before the court until today. But I actually studied that, and I think 9 months is pretty typical. And when in my previous job, and I would advise hearing panels, that's what I would tell them. And then of course it can be shorter than that, obviously, but it can be longer than that depending upon how much cooperation is involved with the petitioner. And I do think in the last case, COVID certainly had a big impact on that as well. And if you're interested in knowing why I want the reinstatement hearing, I'm happy to provide that. But if there's no further questions, I will sit down at this time.
Please, the court. My purpose here today on behalf of Mr. McVey is to ask that the court use something that seems to be ignored in some places in the law anymore, and that is common sense. We're not, from the very get-go, Mr. McVey, along with my office, not one time did he ever deny that he violated Rule 1.15. The time in question is important since he was summarily terminated by Brock McPherson, who he worked for all those years. And that would have been the last part of May or thereabouts. And until Mrs. Keenan, who's the lady that had the house that was being sold on contract or whatever, she wanted a final payment. And he eventually paid her. But it would only be from approximately June until August when the payment was made. And he didn't deny that when he left McPherson's firm, where he hadn't been dealing with a trust account as far as the deposits that were made, et cetera, he thought it would be easier just to use the checking account that he had for his family, well, his wife, and handle it like you would if you were handling a management account for rentals. Now, he knows now that you shouldn't have done that, or he shouldn't have done that. No question. No question. But, and I hate to make this personal, and if it stays that way, I can't help it. From the get-go, the disciplinary administrator's office has said nothing but suspension, period. And it just doesn't fit in this case. We offered to take, well, we tried everything. You take diversion. They said no. And we said, would give us published censure. No. Suspension. Now, suspension is one notch below disbarment. And this just doesn't fall into that category, folks. From all the things that you've heard over the years on disciplinary matters, if what Mr. McVey is accused of doing, if that's going to bring about this type of a suspension, then we're going to have a lot of cases here, it looks like, because that's just not workable. And I hate to, I've lost enough cases over my career that I guess one shouldn't admit vulnerability, should you? But anyway, at the same time that they're arguing for suspension with Mr. McVey, we recently had a decision from Mr. Pistotnik, who pled guilty to 3 misdemeanors that were reduced down in federal court. And his track record in front of the Board of Discipline in this court dates back to November 8, 1985, where he received informal admonition for improper conduct to people of the parties in a domestic matter. In August of 91, he was informally admonished for violating a 1.15. In December of 93, he received a 1-year suspension in the case of Pistotnik, or In re Pistotnik 254, Kansas 294, for diligence, communication, etc. April 7 of 94, he received informal admonition again for 1.15 violation. And in May of 94, he received informal admonition for another 1.15 violation. And he was given a 1-year suspended sentence approved by the disciplinary administrator's office. And in what happened to Mr. McVey, if it doesn't come close And more recently, I would point out, as you probably know or remember, and I don't have all the facts on this case because it involves a good friend of mine who I practiced for and against for many, many years, and that's Terrence Malone in Dodge City. And I don't know all what happened there. I've heard rumors, but whatever the case may be, he was given a 90-day suspension approved by the disciplinary administrator's office in this court. But yet today, the DA's office wants Mr. McVey to stay out for a year. Now, he's going to talk to
How do you reckon, you keep talking about that's disciplinary
I can't
administrator.
hear you.
You keep just mentioning that that's been the posture of the disciplinary administrator from the get-go. I think that's how you said it. And that's still the recommendation. You had an opportunity to put forth recommendations before the hearing panel, and that didn't occur. And you have a group of independent lawyers, Mr. McVey's peers, who recommend a 1-year suspension. How do you respond to that? Heard all this evidence, and that's what they recommend. And it's a panel of experienced lawyers who are recommending this, who have experience being hearing panel members. What's your response to that? And comparing it to other cases isn't very helpful, but tell me, why didn't you take the opportunity to argue this and recommend some sort of lesser sanction? You didn't do it.
I have, I'm going to answer your question. All right. And if it squeezes tight for my client or you find it offensive, I apologize, but I'm not here. All right.
We're not too easily offended, so go ahead.
Well, if I can't tell you how I know this, nor can I tell you that I can prove this, but the way that the hearing handles is postured now, in addition to a court reporter, the office of the disciplinary administrator has an employee, I don't know, staff member, attorney, that I don't know, and they sit down and they take down everything also. And it's my understanding that they write a preliminary opinion also. And it's my understanding that in that preliminary opinion, they incorporate the facts as they took it and as they recalled it. Now, if you look at the opinion that was issued, there's like 40 findings of fact or more that normally, at least, I guess to show my ignorance, when I was on that panel for 14 years, we didn't write them that way. And I'm telling you that I think that the influence of the disciplinary administrator can, in some instances, influence that final opinion. But never have we ever said that we wouldn't accept public censure. And that's still our position to this day. This young man should not be suspended for a year. Let me tell you something, and he'll come up here in just a second. The background of what he went through in working for Attorney Brock McPherson is a whole nother matter that you're not here to decide, nor should I dwell on it, but it's not perfect. And he had no ongoing practice other than take care of McPherson's clients, which included they had a computer printout of some 44,000 plus collections that they would handle. And that's essentially what he did. When Brock McPherson told him to leave and give him his keys and clean out his desk, and it's in the report, that's when, notwithstanding that Mr. McVey had paid for part of the firm, which was just summarily disregarded, McVey didn't have anything else to turn to except start making a living. He has no children, he's married, his wife is disabled. And so he started doing appointments work, criminal, both felony and misdemeanor. And that's what he's doing it now in some 11 counties. He's also a judicial or a city prosecutor. And and he's doing the best he can. He's a valued member of the bar. And I wish we could have made a better showing, but if you want to go through all the records, we could furnish them to you, but not once did they ever come off of this suspension long before it got to the hearing panel. Now, I'm going to try to comply with our time, which apparently hasn't been done too often today. I'd like to have Mr. McVey come forward if you don't mind, Lee. Step right up. Announce yourself and tell them how this has affected you.
May it please the court. My name is Jeff Lee McVey. I go by Lee for whatever reasons my parents can only explain. My business address is 1201 Washington, Great Bend. My Kansas Supreme Court number is 15501. I've admitted from the outgo of this case that I violated 1.15. I've also admitted that at the time I was handling Miss Keenan's, MK's rental properties and her escrow account, that I felt like I was a real estate manager and not representing her as an attorney. Additional investigator, Mr. Schultz and Burscheit and the DA's office has made it very clear to me that I was wrong in making that belief or that assumption. And I acknowledge that and I regret it. And I do apologize to this court for taking its time for being here today as a result of that. However, I would also ask the court to consider or keep in mind that when Mr. McPherson asked me to clean out my desk on May 29th, I've been with him for 27 years. I had entered a buy-sell agreement with him in 1997 and paid him in excess of $25,000. He walked in my office, said, "Pack your desk and get out." Kept all my files, including those files that I prepared and kept over the years for MK. Those files did contain the appropriate paperwork for Ms. K and her real estate properties and the escrow account, because at the end of every year, she needed for her own accounting purposes how much was received, how much went to interest, how much went to principal, and those were always provided to her. However, after Mr. McPherson cleaned out my office and told me to come pick up the boxes that he had packed for me, I went to the office. They were sitting in his front lobby. That's all I was allowed to take. I did not have access to those records beyond May 29th. Any regret? In any event, I do regret the misconduct, and I can assure this court it will never happen again. And part of that assurance, I'd point out that I have 27 years of practice in this state for our disciplinary history. I believe that speaks to my integrity. When I agreed to help MK with the escrow account, I did so at her request. When she sold her rental properties in 2015, I asked her to find another escrow agent because I was not charging her to be her escrow agent and collect those funds, write those checks for taxes and insurance or anything else involved with that account. She did not want to do so, so I kept handling it on her behalf. At that time, she said, "Well, rather than write me a monthly check, I will call you when I want a check." And that's what we did from 2015 moving forward. She contacted my mother in the summer of 2020. I immediately got a check to her for the amount she requested because I did not have access to my records going on the 9th of 2020.
Put her money consistently in the same. And how are we supposed to look at those funds for personal items at Walmart and grocery store?
It does not look good, I admit. I'm embarrassed to admit this, but after I signed the buy-sell agreement with Mr. McPherson in 1997, I did not receive any further raises from that office. 97 to May 2020, making $52,000 a year. About 2014, he had quit paying my monthly expenses, which were running around $500 to $1,000 a month. The firm owed me in excess of $15,000 in expense. Frankly, I was in a tight spot financially. I guess I rationalized it to myself that, well, I'm her real estate manager. I will get the money to her when she asks, because she hasn't asked for it yet. So I wrote the checks. Or admit that here today, but I'm being in all candor with this court.
What about the failure to provide the documentation strike me as it's an uncontested fact in this case that your failure to provide documentation amounts to bad faith obstruction of the disciplinary.
I didn't have the documentation from my files that were at McPherson and McVey law office. Those were not provided to me when Mr. McPherson. I didn't have.
Let's assume that you've got a defense to that. The panel makes the finding, you don't contest it. So when it comes to us, that part's done.
That's correct. And again, in all honesty with this panel, that was advice from my counsel and from other counsel that we conferred with, not to findings and just move forward.
They exist? Records.
Yes, I kept detailed records of what came in, what date, when it was paid out, how much went to interest, how much went to principal. And I had to provide an annual yearly accounting to MK's accountant reflecting that for her tax purposes. I kept the records. The animosity between myself and Mr. McPherson during the last 5 years of my employment there was very high. In the event, I have served on the Great Bend Housing Authority Board of Commissioners for approximately 10 years. I've been Gordon Belt Humane Society. I've coached baseball, Little League Baseball, and Golden Belt Babe Ruth Association previously. Then I'm accepting felony appointments in 11 counties in central Kansas, as well as misdemeanor and child needed care cases. Unfortunately, there's a demand for that kind of legal coverage in that part of the state. I'm doing my best to try to fill that void and help the people that need help with their legal. With that, I would point out that, again, I disagree with the panel's finding that we did not make a recommendation at that time. Mr. Burscheit, I thought, plainly requested public admonition. And I do admit that.
First, Justice Wilson, in response to your question previous, Rule 217A does not require adopting of a complaint before a subpoena can be issued. It just says an investigation under these rules. Not all 1.1 violations are created equal. As Mr. Burscheit was mentioning different cases, didn't talk about kind of what the 1.15 violation was. And there's lots of different types of 1.15 violations, lots of subsections. As Justice Rosen pointed out, comparing cases sometimes is of little value. I do think that there are some, if we dive a little bit deeper on some of the cases, we can find some helpful information. If you look at the Shumway case, I think the Shumway case is, let's see. 269 can 796, it's from 2000. In that case, the court ultimately stated misappropriating client funds is one of the gravest offenses against the public trust a lawyer can commit. And that's what happened in this case, particularly in MK's case. The funds were received, they weren't properly safeguarded, they were spent, and then other funds were paid to her. I think he paid August 6th, and he received the first amount of funds the end of January earlier that year. And in the Shumway case, it's also even more relevant other than just that one line. In that case, Ms. Shumway took an advance fee within days. She spent the advance fee prior to performing any legal work whatsoever, which is, I think, is tantamount to what happened in this case. That case ended with a 1-year suspension with conditions. And In re Ritmaster is another one that's somewhat similar. 299 can 804 2014 case. And in that case, the respondent failed to provide an accounting of funds held on behalf of the client and failed to cooperate in a disciplinary investigation. Again, a 1-year suspension with the reinstatement hearing. In that, I want to comment briefly on the respondent's arguments about he didn't have his records. He never asked Mr. McPherson for the records. Now, maybe Mr. McPherson would have said no, but he never asked. He never asked the office manager. He never asked Mr. McPherson. He never had contact with him again after he left that day on May 29th, 2020. Additional,
In preparation for the hearing, and it's been a long time since I was on that side of the deal, but both parties have the ability to request subpoenas from the panel.
correct. The,
I didn't, your office just subpoena the records.
well, like as I mentioned before, under Rule 1.15 is required to have the records. I actually have a whole, I'm gonna go get my argument because I have a whole page on it. Listen to that. They're required to cooperate in disciplinary investigations. It's a much faster method if the respondent can simply get the records, provide us what he has. If he's already got an accounting done, if he maintained the records as he went along, if he simply asked Mr. McPherson for those and provided them to us, it's a lot faster, it's a lot cheaper, it's a lot more efficient.
Did you know about the toxic relationship between Respondent and Mr. McPherson?
When Mr. McPherson filed his complaint, it was pretty clear that there was a toxic relationship. The complaints included a lot more complaints than the ones we proceeded on. The two that we proceeded on were the only ones that had, that we found to have merit.
When you're saying it was just a lot easier for him to go to Mr. McPherson, I mean, it was clear that this was a toxic relationship, right?
Well, I think it's reasonable for him to ask for his records. And if he didn't get what he needed to have in order to practice law, he should have asked his former employer for the additional records. During this process, I contacted Mr. McPherson's office and I asked for the records, and he provided me with a receipt book, which was immediately forwarded on to Mr. McVey. and
So
his
you did
counsel.
ask for some records.
I asked for all of the records from Mr. McPherson. And he provided the receipt books. And if Mr. McPherson had taken the receipt books and combined that with his bank account, he could have created an accounting, but he didn't. In fact, while he was testifying, Mr. McPherson was asked, Mr. McVey was asked about the records that he did provide, which can be found in Exhibit 6 and 7. And he said that some of those he received from online banking where he was able to just download.
I think I'm confused.
Okay,
You talked to Mr. McPherson.
I talked to Mr. McPherson's office assistant.
Okay. And that person provided you records, the receipt books,
Correct.
but could not provide you the records that Respondent is talking about, which were the accounting for MK.
Mr. McVey described the accounting as something called, what he called a backing, which was a piece of cardboard with like a clip to hold paper on it. And he said that he had a backing, which with his accounting. After I received the receipt book and Mr. McVey communicated that his backing wasn't included, I asked for that and she said there was no such thing in the files. So I received what they provided to me, I provided to Mr. McVey. But my point about the bank records is that it was his personal bank account. He had access to the bank records. He had online access to the bank records. In fact, he printed off some of the bank records to provide what became Exhibit 6 and 7. And when he was asked, why didn't he just print off all of the banking records from that time period and create an accounting? He said that he printed off what he thought was relevant. That's on page 60 of the transcript. And what he provided was simply 1 month during that time frame. And what we needed to, the complaint involved the January through April payments. So what we really needed to have was a time period of starting in January and going through whenever he made the payment to MK, which was August 6th.
Want to make sure I'm clear. But you've got this, so from McPherson's office, you've got this ledger that shows the receipt of money being delivered to the office, right?
It's not a ledger, it's like a receipt book. It's just like a carbon copy of
Fine.
receipt. So there's not like a running balance or anything. And it involves other, I think it involves other receipts.
But it shows the incoming of money.
Correct.
Money was then deposited into bank accounts controlled by Mr. McVey.
Well, yes and no. He says eventually it was deposited, but he also testified that he kept that cash in his drawer and that cash was commingled. So it was.
Was the money deposited in any banks that were controlled by Mr. McPherson?
No. Just briefly, as I'm out of time, unless there are additional questions. You have a question?
I do have one question.
I can tell.
Your opposing counsel made what I guess I would describe as a rather extraordinary statement. So I wanted to ask you about it. Do members of the disciplinary administrator's staff assist the hearing panel with drafting final reports?
In my previous job, I was counsel to the Kansas Board for Discipline of Attorneys, and that was my job. So while I was housed in and that job is now currently performed by Crystal Bokens. So while I was housed in the disciplinary administrator's office, it's the board has complete control over her work. She makes a draft.
Right. So even though that you might describe that as a technical employment relationship, there's a wall of separation, if you will, between the panel and the staff of the panel, and then the prosecutorial wing of your office. Is that correct?
Physical as well as practical.
So they don't, the counsel to the panel doesn't talk to the prosecutor about the case.
No.
Okay. Thank you.
And I'm very familiar with that role since I served that role for 23 years.
Yes, I knew you were. Thank you. So that's why I thought you would be helpful in clarifying that.
Right, and there's no change to that role. I mean, I remember I served on 1 or 2 panels back when I was in private practice, and that was a long time ago. I'm just saying there's no change in that, the way that relationship has occurred since back when I was familiar with it.
No change whatsoever. I do think it's important that we have a reinstatement hearing in this case, and that's because I still think that respondent should provide an accounting of MK's funds. And so that way we can know whether or not she was made whole. He has the receipt book, so he knows what money came in. He has access to his bank records. He indicated an unwillingness to get those bank records because of the charge involved. However, he also talked about the online access. So I think he should be required to establish that he has made her whole by providing that accounting that was asked for such a long time ago. And never move my papers around because then I can't find them when I need them. And I think if there's no additional questions, I'll rest.
I see none. Thank you. Thank you to both or all of you for your comments and arguments today. We'll take this case under advisement.